Will Trump's increased wages and restrictions on H-1B visas hold up in court? Welcome to Voice of Immigration. I'm your host, John Veely, immigration attorney and CEO of Online Visas, the intelligent immigration platform. Pursuant to a Trump proclamation, both the Departments of Labor and Homeland Security issued sweeping regulations on the definition and the requirements of the specialty occupation, the basis of the H-1B visa, and the prevailing wage, the amount of money that must be paid to those that work under that visa, in what was called an interim final rule. The impact will be massive, especially on the tech sector, where the occupation of software developer and other positions have been virtually eliminated and comprises 40% of the H-1B visas. But all professionals will be impacted even if they can get an H-1B visa because the wages required to be paid by the employers has been raised so artificially high it'll be impractical for them to hire entry-level or numerous workers. This will cause jobs to leave the U.S., a major contradiction to one of the promises President Trump said he would address. It will continue to impact foreign students coming to American universities, as the possibility of them entering the workforce will be significantly impacted if the regulations hold up. But will the courts uphold them? Looking at the Trump administration's track record on similar issues, not very likely. What is different in this situation is that the administration used regulations instead of presidential proclamations. The proclamations have been shot down hard recently. One court stated the president's use of the process was unconstitutional because the laws were the exclusive province of Congress, and Congress doesn't even have the power to delegate them to the president. While agency regulations may be harder to undo than a presidential proclamation, as the regs are very comprehensive, and a lot of effort was put into rationalizing why the agencies were compelled to make the changes, it is likely a difference without a distinction. The case will likely turn on the use of an interim final rule. DOL stated in its rules, entitles the good cause to forego notice and comment rulemaking. The Administrative Procedures Act authorizes an agency to issue a rule without prior notice and opportunity for comment when the agency for good cause finds that those procedures are impracticable, unnecessary, and contrary to public interest. Under the APA, notice and comment is deemed impracticable when an agency cannot follow Section 553 and execute its statutory duties. While the public interest prong connotes a situation in which the interest of the public would be defeated by any requirement of advance notice. Generally, the good cause exception for going notice and comment rulemaking excuses notice and comment in emergency situations or where delay could result in serious harm. While emergency situations are the most common circumstance in which good cause is invoked, the infliction of real harm that would result from delayed action, even absent an emergency, can be sufficient grounds to issue a rule without undergoing prior notice and comment. This is what these agencies are trying to do. Citing a case of National Resources Defense Council versus Evans, noting that notice and comment procedures should be waived only when delay would do real harm. Emergencies, not only the situations constituting good cause, are the most common. They also cite Bushman versus Schweiker. The notice and comment procedures in Section 553 should be waived only when delay would do real harm. The good cause exception is essentially an emergency procedure. Well, those cases don't really help DOL here, but it makes 2 points trying to make its argument. First, the shock to the labor market caused by the widespread unemployment resulting from the coronavirus public health emergency has created an exigent circumstance that threatens immediate harm to the wages and job prospects of U.S. workers. The first ground that the pandemic provides some unusual harm for the labor market was tried recently as a justification in the administration's ban on H-1B visa entry and was soundly rejected by the court in Judge White's October 1st, 2020 order in NAM versus DHS. Now, we broke down that case, so please check out the link to that below. Further, the Trump administration is publicly stating the economy is humming and the pandemic impact on the economy is over. A White House press release entitled September Jobs Report Shows American Grit, October 2nd, 2020, stated the Bureau of Labor Statistics released its monthly unemployment situation report. In September, the United States added 661,000 jobs, and the unemployment rate fell to 7.9%. It further states in the last 5 months, 52% of the job losses from the pandemic have been recovered, and the United States has gained more than 11.4 million jobs, including a combined upward revision in July and August of 145,000 jobs. Although this year has not been easy, the grit of the American worker has not wavered, and we are in the midst of the fastest economic recovery in American history. So while the agencies are saying that they have to have this emergency rule without any notice and comment to anybody to do anything about it because the economy is so bad, the administration is saying that it's in the midst of the fastest economic recovery in American history, and that's problematic. But moreover, the employment occupations in which the H-1B workers are usually sponsored has actually decreased during the highest levels of unemployment during the pandemic. We have a chart that shows that in January, computer occupations had an unemployment rate of 3%. All other occupations had 4.1%. In February, computer occupations dropped to 2.4%, and all other occupations dropped to 3.9%. The pandemic came in the middle of March. March, the computer occupations had only a 1.9% unemployment rate, whereas all other occupations had 4.7%. In April, it starts to get much worse for the rest of the world. Other occupations, 15%, but computer occupations only 2.8%, down 0.8% from January when the economy was humming. In May, it drops even further to 2.5%, while all other occupations was still at 13.5%. So again, the basis that they say it doesn't have to be emergency, but it has to be important, are not going to be met by these facts. The second point that DOL makes in using the interim final rule is that even absent an emergency labor market condition caused by coronavirus pandemic, which of course there isn't, provide the public an opportunity to comment before taking the adjustments to the wage levels take effect or contracted public interest insofar as it would impede the department's ability to solve the problems this interim final rule is meant to address. Advance notice of the intended changes would create an opportunity and the incentive to use it for employers to attempt to evade the adjusted wage requirements. So if they made it 60 days out, like the Department of Homeland Security did, they're saying that they would just pay these bad wages or these low wages for these 60 days. And because of that, this constitutes a situation where the public's interest is defeated by any requirement of advance notice, and also justifies the department's decision to forego notice and comment before issuing a rule. The second ground has traditionally been invoked in cases where public health and welfare is at stake, but this rule is being issued well into the fourth year of the administration, which has been attacking the H-1B consistently, and is not in response to any statutory deadline, and the economic justification is merely stated, not backed up with facts. Based on these factors, if the implementation of the rule is challenged in court, it's likely to fail. Further, DHS lost a court challenge when it initially rolled out this STEM OPT, which stands for Optional Practical Training regulation, as an interim final rule. So stay tuned as we watch out for the filing of these cases by IT Serve Alliance, by its attorney John Wasden, and the U.S. Chamber of Commerce, and possibly others. If you're a company that wants to better understand how these new regs may impact you hiring H-1B workers, or an individual that wants to apply for an H-1B visa or any other visa, go to onlinevisas.com and schedule a free strategy session. If you're watching on YouTube and you want to stay up with these ever-changing issues, please subscribe and turn on your notifications. If you like the content, please like and please share with your friends. I'm John Veely, CEO of Online Visas, the intelligent immigration platform where we deliver dreams.